All rise. We would have. The International Criminal Court is now in session. The Joint Court Panel International at Uwait. Please be seated. We will as well. Good morning, everyone. Mr. Court Officer, kindly call the case.
Good morning, Mr. President. Good morning, Your Honours. This is the second situation in the Central African Republic in the case of the prosecutor versus Maxim Geoffroy Eli Mokom Gawaka. Case reference ICC 0114-0122. And for the record, we are in open session.
Thank you very much. Like yesterday, I kindly asked the parties just to reconfirm whether the teams are the same or if there's any change to state it for the records. Mr. Prosecutor.
Bonjour, Monsieur le Président, Madame, Monsieur le Juge. Le bureau du procureur est dans la même composition que les 2 jours précédents. Merci.
Thank you very much.
Bonjour, Monsieur le Président. Bonjour, Madame, Monsieur le Juge.
Merci, Monsieur le Juge. La composition de la défense a varié un peu ce matin. Nous avons derrière Nina Guillou, qui s'est joint à nous, et également Bonnie Johnston, qui est derrière ici. Sinon, la composition de l'équipe de la défense reste la même. Bonne journée.
Thank you very much.
Monsieur le Président.
Good morning, Mr. Representative victims.
Oui, Monsieur le Président, bonjour. Les représentants communs des victimes sont les mêmes qu'hier, sans changement. Merci.
Thank you very much. Okay, today we have an agenda continuing with the defense submissions on the merits. According to our calculations, you have 1 hour left, 60 minutes. So the floor is yours.
Good morning, Mr. President, Your Honours, and good morning to colleagues around the courtroom. It's a privilege to be appearing before you today on behalf of Mr. Maxim Mokom. As lead counsel said, I will be speaking about the modes of liability charged in the present case. How is Mr. Mokom alleged to be responsible for the charged crimes? What are the elements that the prosecution needed to prove? And have they done it? I don't anticipate needing to move in and out of private session. And we want to start today with what we see as being the evolution of the prosecution's case against Mr. Mokom, as between the request for an arrest warrant in 2018, as compared with the document containing the charges that was filed on the 9th of March 2023, as compared with the case that we heard from the prosecution on Tuesday, where we can trace this significant reduction in the scope of the case against Mr. Mokom. And on Tuesday, we heard that the prosecution's theory has narrowed right down to this central thesis that Mr. Mokom should have known that the anti-Balaka were committing crimes because there was so much media that one could not escape it, and that he didn't walk away when a reasonable person would have. And this is at the real-time transcript of the 22nd of August, page 93, lines 2 to 13. And this is how the prosecution ended their submissions. Mr. Mokom made his choice. He should have known and he didn't walk away. This could not be further from the case that the prosecution came with to this court when it asked Mr. Mokom to be found and arrested in 2018. At that point, the prosecution's case was that Mr. Mokom was committing the crimes and would be charged together jointly with others under Article 25(3)(a) of the statute. But this fell away when it became time for the prosecution to frame a case for confirmation, presumably because nowhere in the evidence do we see Mr. Mokom committing crimes. There was never any suggestion, either in 2018 or now, that he was liable as a commander, that he had effective control over the anti-Balaka troops, and that's right, there is no command case here. Instead, the prosecution has moved down through Article 25.3 and has framed Mr. Mokom's liability not as committing, not as ordering, not as commanding the perpetrators, but as aiding and abetting under Article 25.3c and contributing to a group acting with a common purpose under Article 25.3d. And it's not controversial to say that these forms of liability already indicate a more remote or arm's length contribution to the crimes, or as said by the appeals chamber in the Lubanga appeal judgment at paragraph 462, a lower form of blameworthiness than an accused who commits the crime themselves. So we have Mr. Mokom not commanding the troops, he's not in the mix committing the crimes, but he's away from the crimes, including during the critical period of the charged 5 December attacks across the border in Zongo. The flip side of this kind of charging is that when you have a suspect that's more removed from the crimes, the obligation on the prosecution is heightened to show how that link can be made between the suspect and the charged crimes. Where does this link come from in this case if Mr. Mokom isn't committing the crimes, he's not commanding the perpetrators, he's not giving orders? And this pre-trial chamber, in the Yekatom and Ngai Sona confirmation decision, recognised, rightly, the need for a link to be established between the suspect and the charged crimes, and found that where the evidence of that link is flimsy or otherwise inconsistent or inadequate, the charges cannot be confirmed. So we're going to look at these two modes of responsibility today, starting with aiding and abetting under Article 25.3c, and then moving to perhaps the more controversial common purpose liability under Article 25.3d. But firstly, I just want to address quickly the question of evidence. When we talk about the inadequacy of evidence, or flimsy or inconsistent evidence, what do we mean? The DCC in this case is 70 paragraphs long. It was disclosed on the 9th of March this year, together with this Annex C1. Annex C1 lists the 70 pages of the DCC, the 70 paragraphs, with each of the supporting accusations underneath. And then there's this second column, which lists all the evidence that the prosecution says supports the supporting allegations. And we are confident that the chamber has done the same exercise that we've done, which is to extract all this evidence and read it and look at the extent to which it supports the allegations. To be clear, Annex C1 is the prosecution putting its case at its highest. This is not a complete picture of all of the evidence relevant to all of the allegations. This isn't the incriminating evidence. There isn't a third column which sets out all the evidence that would undermine the prosecution case, which we now know exists. We know in this case there are 425 pieces of evidence that have been framed as exonerating by the prosecution itself. Annex C1 is just the incriminating evidence. This is the prosecution's case at its absolute highest. And we can see that a significant amount of the evidence cited in Annex C1 comes from the statements of prosecution witnesses, many of whom have now come to The Hague.
Slow down, please.
And testified in the Yekatom and Ngai Sona trial. And they've been cross-examined. And where those prosecution witnesses have said something different under oath, something favourable to Mr. Mokom, or even something just inconsistent with the prior statements, that's not reflected here. That hasn't been captured in Annex C1. a concrete example, going straight to the common purpose, the first major accusation in the DCC. Annex C1 says at line 6 that the anti-Balaka targeted the Muslim population. The first witness cited in support of that allegation is P808 and his witness statement, CAR OTP 2093-0010, where he says at paragraph 40, that's cited, that the anti-Balaka killed many innocent Muslim civilians, women and children. But when P808 came to testify, he was cross-examined on this paragraph 40, on this very allegation, and he clarified, this time under oath and in open session, well, difficult for me to say whether or not it was civilians or the anti-Balaka who committed the crimes. And he said that's what caused all the confusion. And that's at transcript CAR OTP 0000-1107 at pages 13 to 14. So we have a prosecution witness saying something incriminating in Annex C1, which he then retracts or clarifies in his live evidence, but the prosecution just stops at the statement. And so this annex doesn't reflect the actual state of the prosecution evidence, and so it's inaccurate. And we picked this example from other examples where statements relied on in this annex have been reversed or clarified when the very same witnesses have come to testify. So we would firstly invite the pretrial chamber to consider the totality of a witness's evidence before they accept what's attributed to them in Annex C1, particularly to see if they've said something different, because the prosecution has not done that exercise for you. This is its case at its absolute highest. More examples to come. But coming back to the modes of responsibility, we're going to start with aiding and abetting under Article 25(3)(c), and the prosecution is required to demonstrate that Mr. Mokom aided, abetted, or otherwise assisted in the commission or attempted commission of the charged crimes, and that this assistance, so what Mr. Mokom did, had a causal effect. So it furthered or advanced or facilitated the commission of the crime. And this is where we say there is a black hole in the prosecution's case. And it's the reason that the prosecution presented firstly the crimes and then made a separate presentation on Mr. Mokom's contribution, but didn't take that critical step of linking his alleged contribution back to a single charged crime, because that evidence doesn't exist. And it's not enough for the prosecution just to allege general assistance to the anti-Balaka generally, or even just assistance to the anti-Balaka in a particular region. The prosecution is required to demonstrate that Mr. Mokom's assistance contributed specifically to the charged crimes in the DCC, in those locations and on those dates. And what's useful is looking to other cases to see what sort of evidence has been accepted as demonstrating that link. In the Taylor case at the Special Court for Sierra Leone, which is probably the most well-known aiding and abetting case, the prosecution was able to demonstrate that President Taylor had provided arms and ammunition, specific and identifiable shipments to the RUF AFRC, with details about where they went and to whom, and more importantly, how they were used, in which attacks and by whom, in what timeframes, to commit the charged crimes. and I'm referring to the evidence outlined in the Taylor trial judgment at paragraphs 5528 to 5573 and the finding in 6911. The same with military personnel. At paragraph 6922, the prosecution was found to establish that President Taylor sent a group of 150 fighters to an RUF battalion, which was then deployed in particular attacks in December 1998 in Kamena, which contributed to the charged crimes.
Madam, you need to slow down and observe pauses between sentences. Otherwise, the work of the court reporters and the interpreters would be very challenging.
My apologies, I'll
Thank
do
you.
my best. This is the level of detail that has been required before aiding and abetting liability kicks in. Similarly, at the ICTR, in the Ngiribatware case, the prosecution was found to have demonstrated that the accused Augustin Ngiribatware came to a roadblock on the 7th of April 1994 and provided machetes to particular Interahamwe, two of whom are named, and the trial chamber was satisfied that at least some of these weapons were used during the attacks and killings in Nyamyumba commune to commit the charged crimes. This is the Ngiribatware trial judgment at paragraphs 1335 to 1341. So not just general support, not just general supply of weapons, there has to be a link between the assistance and the charged crime. And you might think, okay, well, that was the standard at the tribunals, and this is the ICC. But this level of evidential detail has also been required for aiding and abetting at this court. In the Bemba Article 70 case, the trial chamber required the prosecution to demonstrate that specific assistance to a particular witness corruptly influenced their testimony, which was the charged crime. The accused Fidel Babala, for example, was held to be the general financier of the scheme to corruptly influence witnesses. And in paragraphs 877 and 878 of the trial judgment, the chamber said it's not enough to just rely on general assistance in financing the scheme. The prosecution was required to establish that his particular assistance to particular witnesses would have influenced to give them false testimony. And for some witnesses, the prosecution had that evidence, and for others it didn't. And you might think, well, those were all trials, and this is a confirmation. The link doesn't need to be here, or it doesn't need to be here with that level of detail. But we can see in the Yekatom and in Guyasona case, this pretrial chamber correctly also required precisely this kind of evidence. At paragraph 176 of the confirmation decision, the pretrial chamber held that the prosecution evidence of aiding and abetting was too general for charges in particular regions. And it found that, and I quote, "The evidence presented by the prosecutor does not allow the chamber to trace Ngayasona's financial contribution or otherwise to the anti-Balaka groups operating in those locations." So that's what's needed. Where are we in this case? With Mr. Mokom, we are nowhere near the level of detail needed. Annex C1, the prosecution's case at its highest. no cross-examination of these witnesses, no exculpatory evidence. In Annex C1, the prosecution says that Mr. Mokom's contribution was firstly giving money to the anti-Balaka. And this is from page 48 of Annex C1. Mr. Mokom allegedly funded the anti-Balaka through selling his house in Zongo, and then channeled financial support from the Bozize family to buy weapons and ammunition for the anti-Balaka. Lead counsel spoke to you yesterday about P2232 and the problems with his evidence here. Apart from him, there is nothing, there is no direct evidence from anyone allegedly involved in these transactions. No witness claims to have seen or transferred or handled or received these funds in any way. There's no documentary evidence, there's no bank transfers, Western Union transfers, or documents from the sale of a house, which would all leave a trace. But even if there was credible evidence of funds being transferred from or by Mr. Mokom, and remember that P405 said that Mr. Mokom was living in misery in Zongo, you know, with nothing, with nowhere to sleep. People had to give him clothes. And this is at CAR OTP 2107 4722 at pages 4742 to 4743. Even if there was credible evidence that Mr. Mokom was the conduit for millions of CFA to and from Zongo, the prosecution doesn't then make a link between these funds and the charged crimes. Nothing about where these alleged funds were sent, to whom and why, and how they then facilitated the specific charged crimes in the indictment. Because there isn't any evidence of that. And we presume that this is the reason that the evidence of funding of the anti-Balaka wasn't addressed during the prosecution's submissions on Tuesday. What about weapons and ammunition? Lead counsel has gone through the prosecution evidence here, explaining the problems caused by the details in the evidence that was skipped over by the prosecution, and that the prosecution cannot link any arms or ammunition allegedly from Mr. Mokom to the charged crimes. There's no attempt by the prosecution to show that these guns, that this ammunition came from the suspect to these groups and were used in the charged crimes. And were used not to defend against Seleka combatants or to attack military objects, but were used to murder civilians on that date as charged, used to rape civilians on this date as charged. Because that evidence doesn't exist. It's not in the case file. And this is the difficulty with this case, that you have this underlying armed conflict, according to the prosecution, that even if the prosecution could demonstrate that the anti-Balaka were using weapons that had been supplied by the suspect, that's not enough. They have to demonstrate that the weapons were being used to commit the crimes charged. If the prosecution had managed to show you that, then maybe we would need a trial. But we don't have anywhere near that kind of evidence. And this is just the actus reus. The bigger problem for aiding and abetting comes with the mens rea. The prosecution is required to establish that Mr. Mokom gave this assistance for the purpose of facilitating the charged crimes. With that purpose. This specific language was included in Article 25(3)(c) itself. It's not sufficient that Mr. Mokom knew or should have known that his assistance would help the perpetrators. That was the standard at the tribunals. At the ICC, the term purpose was included in this article, and it goes beyond the ordinary mens rea standard in Article 30 and requires this higher subjective element to be satisfied. And we just don't know where that evidence is to show that Mr. Mokom gave his assistance with the aim of facilitating murder, with the aim of facilitating rape. The weight of the evidence shows the opposite. And we don't need to go any further than the prosecution evidence. P 1961, saying that Mr. Mokom wanted to eliminate all the illegal checkpoints, to stop the raids and stop the stealing, that he advised the anti-Balaka not to take justice into their own hands, but to bring those who committed crimes to justice, that he gave people, including the witness, instructions on how to arrest fake anti-Balaka, and he organised trainings on how to work for social cohesion. And this is CAR OTP 2090 0067, paragraphs 90 and 109, marked by the prosecution as PEXO. 91. You said 90. I said I correct paragraph 91. P2503 describes a phone call that he had with Mr. Mokom in December 2013, where Mr. Mokom said that the aim of the movement was not to harm the population, but rather to save the population from its executioners. And Mr. Mokom told the witness to make sure there was no disorder or anything like that. CAR OTP 2118 8955 at pages 8980 to 8981, marked by the prosecution as PEXO. P1521 testified in Yekatom and in Gaisona in open session about how precisely to avoid crimes, to avoid excesses, Mr. Mokom was appointed as coordinator. This is the transcript, CAR OTP 0000 0911, page 22, lines 7 to 10. P405 said that after Mr. Mokom arrived from exile in the DRC, he came back to the movement to try to organise things so that the crimes would stop. He said that Mr. Mokom was also a victim, that he had suffered a lot, and he came back so that the anti-Balaka could get organised. And he took it into his own hands so that the crimes would stop. And this is CAR OTP 2107 4580 at pages 6606, 4606 to 4608, marked by the prosecution as PEXO. is there any direct evidence from Mr. Mokom of his intent, what he was actually thinking? At line 153 of Annex C1, the prosecution cites to a document which is called in French the projet d'appui, and the prosecution attributes this document to Mr. Mokom. It has his signature on it. And on its face, it's a plan to rebuild the country from July 2015 onwards. It says to bring it back to the peaceful times before the Seleka arrived. And in this document, Mr. Mokom talks about the importance of Central Africans realizing that they are all one people, and that this understanding will allow them to see each other as brothers and sisters and as one nation, whether they're Christians or Muslims or animists or sect followers. And this is at CAR OTP 2093 0344 at 0346. And it's not unusual in international criminal cases to have accused who have made public statements calling for unity or calling for ethnic harmony. But this isn't evidence of public statements. This is prosecution evidence. This is people who knew and interacted with Mr. Mokom at the time of the events and who corroborate each other on the fact that he worked to discourage and stop criminal conduct. The prosecution cannot establish on this evidence substantial grounds to believe that Mr. Mokom aided and abetted the charged crimes. The links aren't there, so the actus reus isn't there, and the mens rea isn't there. So, turning then to common purpose liability under Article 23D of the statute, which again allows an accused to be held liable for crimes that he didn't physically commit and that he didn't order and where he didn't command the perpetrators. But again, the trade-off for this broad net being handed to the prosecution is the high threshold for establishing the link between the crimes and Mr. Mokom. Again, there needs to be a contribution and there needs to be relevant intent, and there needs to be a group acting with a common purpose. So let's go there first. The common purpose in this case is set out in the DCC at paragraphs 3 and 4. And what's important to firstly note with the framing of the common purpose, which is framed differently in a number of ways from the Yekatomin and Guyasona common purpose, what's important to note is that the prosecution has gone nuclear and it has put all of the charged crimes into the common purpose itself. At paragraph 4 of the DCC, this common purpose included at least the charged crimes. So all 20 of them. Which means, to start, the pretrial chamber has to be satisfied that there's a group of people acting together with a common purpose to commit all of these 20 charged crimes. Acting together with a common purpose to commit rape, with a common purpose to commit murder. This is a huge burden that the prosecution has set for itself. Who is said to have this common purpose? The anti-Balaka. The anti-Balaka. So everyone, there is no nuance here. None. Reading these charges, everyone in the anti-Balaka, anyone who at any point in time considered themselves to be part of the anti-Balaka is working together with a common purpose to commit all of the 20 charged crimes. That's the prosecution's actual case. But we then saw some incredibly important nuance coming into this case during the prosecution's submissions on Tuesday. For example, at the real-time transcript of the 22nd of August, page 87, lines 12 to 14, the prosecution said, and I quote, "Many anti-Balaka fighters would not distinguish between Seleka fighters and Muslim civilians." Many would not distinguish. So logically, other anti-Balaka fighters would distinguish between Seleka and Muslims. We saw the prosecution referring carefully and deliberately, when it talked about the common purpose, not to the anti-Balaka as an entire group having the common purpose, but, and I quote, "the anti-Balaka who committed crimes against the civilian population acting with a common purpose." For example, at the real-time transcript of 22nd August, page 67, lines 13 to 14, page 68, lines 24 to 25. And the prosecution then cited at page 68, lines 18 to 24, to the evidence of P2087 and his statement that in the lower ranks, the perceived enemy simply became Muslims in general. So in the lower ranks, so not throughout the anti-Balaka. Same transcript, page 53, lines 5 to 7, the prosecution then makes a massive concession, and it says, and I quote, "For counts 2 to 4, there is evidence that Bangui civilians also took part in these destructions. All destructions may not have been committed by the anti-Balaka only." So, we have the prosecution recognising that some crimes were committed by anti-Balaka, but others were committed by civilians, fake anti-Balaka, recognising that there was some anti-Balaka committing crimes in the lower ranks and others weren't. Some assimilated Muslims with Seleka and others didn't. And these nuances are important, and they are honest, and they are entirely realistic, and they are reflected in the evidence. But the prosecution now has an evidentiary problem, because these concessions make it impossible for the prosecution to make a case under Article 25(3)(d). This chamber cannot safely conclude that the anti-Balaka was a movement acting together with a common purpose to commit all of the charged crimes, which could never be established on the evidence anyway. This pretrial chamber cannot safely conclude that when Mr. Mokom was contributing to the anti-Balaka, he was contributing to those parts of the anti-Balaka that were committing crimes. Those parts that he...
Slow down. Observe pauses between sentences, please.
Thank you, Your Honour. Those parts of the anti-Balaka that he himself designates as fake anti-Balaka. Mr. Mokom talks in the evidence about giving instructions to arrest fake anti-Balaka and bring them to justice. Because the prosecution doesn't give that level of detail. It never says these crimes on these dates in these locations were committed by the anti-Balaka that Mr. Mokom was contributing to, and not by civilians, and not by fake anti-Balaka, for this reason or this reason. This could never stand up at trial. The Article 53D charge would fall at this first hurdle. But of course, there are other obstacles. Next, the prosecution has to prove that Mr. Mokom contributed to the charged crimes. And here, it's useful to recall what the prosecution said about this question of contribution in its oral submissions. And this is at the real-time transcript on the 22nd of August, starting at page 86, line 24. The prosecution said, and I quote, "Now let me be clear. The prosecution is not suggesting that it's a crime under the statute simply to support the military activities of an armed group. But such support may lead to criminal responsibility if it contributes to the commission of crimes under the statute." So, what contribution do we need? The chambers in Katanga, in Ruto, in Barishimana have all set the standard of contribution for common purpose liability as a significant, or at least significant, contribution to the crimes. Not just to the group, generally, but to the charged crimes. What makes a contribution significant? Relevantly for Mr. Mokom, the ICTY trial chambers, starting with the Kavochka case, have looked at a variety of factors, including efforts made to prevent criminal activity. And this same language was adopted at the ICC in Barishimana, which makes sense. How can you be making a significant contribution to crimes if you're making efforts to prevent them? The prosecution evidence shows Mr. Mokom taking steps to prevent criminal activity. And let's talk about what the prosecution said in its submissions about what Mr. Mokom actually did when he came back to Bangui. Putting aside the selling of his house that he didn't have, and the Facebook messages he didn't write, and the alleged money, and the 9 Kalashnikovs, how did the prosecution itself actually frame his actions? And this is at the real-time transcript of the 22nd of August, page 84, from line 13. The prosecution says, and I quote, Mr. Mokom then toured the different bases in Bangui, and at this time, when he was proximate to the crimes of the anti-Balaka, he strove to make them more efficient, more structured. He was involved in a number of activities as operations coordinator, including the setup of military police, the billeting of elements, measures to enlist, and to assist in getting anti-Balaka detainees released, including setting up military police. Why do you set up military police? Why do you try and make the groups more structured? Why do you billet troops and give them a place to live and something to eat? To stop crimes. And if the prosecution won't say it, that's fine, because the prosecution witnesses themselves say it. That Mr. Mokom came back to take matters into his own hands and to stop crimes. The inferences that the prosecution wants this pretrial chamber to draw, that Mr. Mokom was intending crimes because he should have known about them and the reasonable person would have walked away, cannot just circumvent this evidence. And to talk about the fact that a reasonable person would have walked away, remember that at this time, the Seleka was still raping and killing and torturing Central African women and children. To talk about what a reasonable person would have done has to take that into account. And the prosecution is asking you to draw an inference that Mr. Mokom is guilty of these crimes because he knew about them and he didn't walk away, but it hasn't offered you a satisfactory path to deal with all the evidence that says the opposite, that he was working to commit crimes. It just designates all that as PEXO and then ignores it. And this is why the prosecution case has narrowed and narrowed and narrowed right down to a should have known case. Foreseeable consequences. In 2018, it was he intended these crimes and he committed these crimes, right down today to, he should have known and he didn't walk away. The elements of common purpose liability are also not present. Article 25(3)(d) liability cannot be established on these facts against this accused. I want to come back around to the evidence in this case to finish up. First principles about the approach to evidence. And I'm not going to talk about the risk of relying on media reports or human rights reports. The pretrial chamber knows all of this. We're confident that you will assess the evidence in line with the proper standards. But one thing that stands out in this case file, in all of the migrated and disclosed documents, is the lack of directly incriminating evidence against Mr. Mokom. Put aside the Al Jazeera videos and the graphic, horrific photographs, what do the prosecution witnesses themselves actually say about what Mr. Mokom was doing? There is no direct evidence of Mr. Mokom giving orders to commit crimes or committing crimes or being present and encouraging other people who are committing crimes. Instead, the prosecution's case is built on circumstantial evidence. You are being invited to infer, to draw inferences that when Mr. Mokom was doing anything to support or guide the anti-Balaka troops, this pretrial chamber can safely infer that he was doing this with the purpose of facilitating or advancing the commission of crimes. And with that in mind, it's worth reflecting on what the purpose of this exercise is. What we've all been doing here in this courtroom over the last few days. We're engaged in an exercise, the goal of which, as the Mbari Shumana pretrial chamber said, is to separate those cases which should go to trial from those which should not. This confirmation hearing needs more than a case where the prosecution still needs the pretrial chamber to make these leaps in reasoning, to draw these inferences in order to get even to aiding and abetting and common purpose liability, the weakest forms of liability under the statute, to get to places that would be obvious if Mr. Mokom had actually been committing international crimes, where the prosecution is relying on evidence that has been retracted by its own witnesses as part of the foundation of its case, where in the prosecution's own witness statements, we can see the suspect taking active steps to stop crimes. We have seen what happens in this court when cases are confirmed without sufficient evidence supporting them. And the results are not good for anyone. This is precisely the kind of case that should not make it past this next barrier, and that the confirmation phase was designed to separate out. Thank you very much, Mr. President and Your Honours. This concludes the presentation of the defence submissions.
Thank you very much.
If you
Mr.
allow me,
Lasher.
Your Honor, a quick correction. The real-life transcript at page 21, line 9, said that Mr. Mokom, he was working to commit crimes, whether the exact opposite was said. He was working to prevent crimes. So the transcript here reflects the opposite of what Maitre Gibson actually said.
Thank you. They always checked afterwards, and I fully trust the registry staff. Thank you very much for pointing this out. Now, we came then to the end of the submissions of the defense on the merits, then we shall proceed with the final statements, and the floor is to the prosecution. You have 30 minutes.
Merci beaucoup, Monsieur le Président, de nous redonner la parole pour une réponse aux arguments de la défense. Cette défense qui a consacré une bonne partie de son temps de parole, je dirais plus de 3/4, a discuté en détail de la crédibilité et de la fiabilité de plusieurs témoins de l'accusation. Elle a mis en doute les circonstances et la manière dont ils ont été interrogés par l'accusation. Nous allons y répondre. Et ma jeune collègue à ma gauche, Colin Gilg, va y pourvoir tout de suite. Mais je tenais quand même, avant qu'elle aborde ces questions de fond, de rappeler quelques évidences. Et je le ferai en commençant par là où le Conseil de la Défense a terminé. C'est-à-dire, quel est l'objet de cette procédure qui nous a réunis ici ces 3 jours. La procédure de confirmation des charges n'est pas censée être un procès. Et ce que la défense a tenté de faire, c'est de transformer cette audience en procès avant la lettre. Bien sûr, nous tous, nous savons qu'il faut un procès pour évaluer la crédibilité des témoins à la lumière de la présentation complète des preuves par l'accusation et la défense. Monsieur le Président, Madame, Monsieur le Juge, aucun témoin n'a comparu ici. La raison en est bien simple. L'évaluation des charges se fait sur pièce et suivant un seuil d'admissibilité de preuves qui est relativement bas, comme du reste la défense l'a rappelé elle-même. La confirmation des charges, de par sa conception même, n'est pas le forum approprié pour répondre de manière adéquate aux questions qui ont été soulevées par la défense. Dans cette procédure, on se suffit de ce standard pas très élevé, ce standard auquel on a souvent fait référence, on parle de prima facie. Je ne dis pas ça pour dire que vous n'avez aucun contrôle à faire. Bien sûr, une chambre préliminaire peut évaluer les ambiguïtés, les incohérences et les contradictions dans les preuves. Mais elle doit le faire avec beaucoup de circonspection, aux seules fins d'éviter des poursuites fantaisistes. Et Madame, Monsieur le Juge, même quand vous avez des doutes, il peut vous arriver, même quand vous avez des doutes, vos doutes ne devraient pas être forcément traités comme les doutes du juge du fond, comme les juges de la chambre de première instance. Ces doutes ne devraient pas entraîner ni ipso facto, ni ipso jure le rejet de la preuve. La prudence, qui doit être de rigueur, se justifie d'abord parce que la preuve partielle, et comme vous avez vu souvent, on vous a extrait des paragraphes qu'on vous a cités là, elle peut se développer. Elle peut apparaître sous un meilleur jour dans le cadre du procès, avec notamment des témoins qui explicitent certains éléments. Et ensuite, et ça aussi, vous le savez, la détermination finale de la preuve, vraiment, est le domaine du juge du fond. Je voudrais juste rappeler 2 exigences qui préside à votre mission. Et là, je le fais en paraphrasant d'ailleurs la chambre préliminaire 2 dans l'affaire Yakatom Ingaïsona. D'une part,
Slow down a little bit, sir, please.
d'accord. D'une part, vous protégez le suspect contre les accusations injustifiées et infondées en vous assurant que seules les personnes contre lesquelles ont été portées des accusations suffisamment sérieuses allant au-delà de la simple théorie ou du simple soupçon sont traduites en justice. D'autre part, vous ne devez prédéterminer ou préjuger la force des preuves. C'est d'ailleurs à ce prix que vous préservez la présomption d'innocence. Et cette chambre préliminaire, dans l'affaire que je viens de citer, a rappelé à juste titre qu'à ce stade de la confirmation des charges, les questions de crédibilité des témoins ne doivent être abordées que si la réponse est manifeste. Sommes-nous ici, et ça c'est la question qu'on devrait se poser, sommes-nous ici dans cette hypothèse où l'absence de crédibilité des témoins est si manifeste que le dossier ne mérite pas qu'on veuille en savoir davantage? Peut-on regarder objectivement le dossier soumis et dire qu'il est vide de charges? Je crois que même la défense ne dit pas cela. Nous avons plutôt une défense qui semble faire feu de tout bois. Une défense qui d'ores et déjà, et nous l'avons entendu de la bouche même du suspect, qui nous dit, qui parle déjà de l'état de nécessité, de légitime défense. Une défense, hier vous l'avez entendu, qui vous dit que la preuve est accablante. Une défense qui vous dit the evidence is damning. Mais en même temps, qui continue pour vous dire oui, mais il y a seulement un problème. Les témoins qui portent cette preuve sont des menteurs. Et pourtant, quand c'est commode, cette même défense s'appuie sur ces témoins, le reconnaissant ce qu'elle appelle des moments de lucidité, des moments d'honnêteté. Donc, voilà, c'est-à-dire une défense donc, qui fait feu de tout bois, qui récuse que toute coordination ait eu lieu au niveau des actions anti-Balaka, mais qui par endroits, quand même, nous décrit des codes de conduite, qui nous décrit un code de conduite, ne tuez pas, ne volez pas, et bien entendu, il n'y a personne pour s'assurer de la bonne marche de ce code de conduite. Voilà. Donc une défense qui présente Mokom comme un personnage insignifiant par endroit. Mais par endroit, il nous le dit que, voilà, pourtant c'est lui-même en fait, qui prescrivait les ordres de ne pas tuer, les ordres de préserver les innocents. Celui qui devait instituer une police d'État et qui représentait les anti-Balaka à travers pour parler de paix. J'évoque pêle-mêle ces références. Madame Gill, comme je vous ai dit, va revenir dans tout cela. Donc, je les évoque non pas pour les discuter, pour dire que ça ne mérite pas de discussion, ou bien pour polémiquer sur les allégations de témoins avec toute leur partie, mais simplement pour dire que nous sommes certainement loin. Nous sommes très loin de l'hypothèse d'un dossier qui serait tellement vide que la Chambre devrait dire « Passez, il n'y a rien à voir ». Voilà, donc je tenais simplement à faire cette petite précision avant de passer le flambeau à ma jeune collègue Colin Gill pour répondre de façon plus détaillée à certains arguments de la défense. Je vous remercie.
Thank you, sir. Madam Prosecutor, you have the floor.
Good morning, Your Honors. It is my privilege to appear before you today. I will continue the prosecution's response to issues raised by the defense during the hearing. I plan to address the following three issues in turn. First, whether Mr. Mokom's conduct contributed to the crimes of the anti-Balaka. Second, whether Mr. Mokom had the requisite mens rea at the time of his contributions. And third, witness credibility. Turning to my first topic, contributions. Your Honors, you've heard what the defense and even Mr. Mokom himself had to say about his role. We heard about Mr. Mokom supposedly being a petit person, apparently only joining the anti-Balaka in February 2014 when he returned to Bangui, and purportedly, it seems, only ever working for peace. But Mr. Mokom was not just working for peace. The evidence relied on by the prosecution shows that Mr. Mokom worked actively to help support anti-Balaka military operations from as early as June 2013. And this contributed to the charged crimes. Indeed, he was part of the anti-Balaka well before February 2014. And the role as operations coordinator that he took on when he returned to Bangui in a formal way developed out of his prior actions supporting anti-Balaka military operations. The defense themselves had relied on a witness when he described how Mr. Mokom visited the comm zones the very day of his return to Bangui. He addressed them and gave them instructions. I refer your honors to yesterday's transcript, T7, page 87. Your honors, this is the conduct of someone who has long been a person of influence, known to these comm zones already because of his previous interactions with them, not someone who just joined up with the anti-Balaka that day. In relation to the charged crimes during the attacks in Bangui and Bosangoa, we have highlighted the evidence in support of his contributions yesterday. Today, I would just like to draw your honors' attention to a notebook with contacts which Mr. Mokom kept in Zongo. This is a notebook kept prior to the 5th December 2013 attack. It will be on evidence 2, and it should not be displayed to the public. The reference is CAR OTP 21002602. Your honors, the 5 pages of this notebook are filled with names of known anti-Balaka elements. And your honors can see here names we heard about on Tuesday. Konate, Ingabona, that's Angelo, Alfred Rombot, that's Yakatom. These are all key leaders of the 5th December Bangui attack. And your honors can also see here Lieutenant Abel, that's Semanganai, and Bruno Semdiro. We also mentioned these. These are 2 of the fighters sent over from Mr. Mokom's Zongo group for the Bangui attack. Your honors, call data records also contradict the defense argument that Mr. Mokom only worked for peace. The call data records alone cannot tell us what Mr. Mokom was talking about, no. But they corroborate witness testimony. And on some occasions, there really is not any other reasonable alternative interpretation of the context, other than that Mr. Mokom was in that moment supporting an anti-Balaka operation. Can it really be a mere coincidence that Mr. Mokom happened to communicate multiple times with the 2 leaders of the Bosangoa attack right before they lead the attack? And can it really be just a coincidence that that same day, 5th December, Mr. Mokom just happens to also communicate multiple times with key leaders of the Bangui attack, even while the attack was ongoing. This is not mere coincidence. This is important evidence of Mr. Mokom's direct link to the attacks during which the charged crimes were committed. Before I move on to mens rea, I want to clarify a few points of law relevant to points raised by the defense, especially today. In relation to the defense argument that Mr. Mokom's contributions, or at least some of them, seem innocuous on their face, these types of contributions can still be relevant contributions as a legal matter. And as a matter of law, for liability under Articles 25(3)(c) and D, the contributions do not have to be criminal as such. And there's jurisprudence on this. I can refer your honors to the Bemba et al. Appeal judgment, paragraph 810, in the context of co-perpetration. The defense's argument about the neutrality or the apparent innocuous, innocent nature of Mr. Mokom's contributions is therefore besides the point when assessing this element. It is also not required that Mr. Mokom was in the place of the crimes for his actions to contribute to their commission. I can refer you here to the Al-Hassan confirmation decision, paragraph 945, and the Katanga trial judgment, paragraph 1636. Also, the contribution as a legal matter does not have to be made directly to the physical perpetrator. Indirect contributions are sufficient. And I refer you to the same passage of the Al-Hassan confirmation decision and paragraph 1635 of the Katanga judgment. And this also shows that proximity of the person to the crime is not required. What is relevant is simply that Mr. Mokom's conduct in its totality contributed in some way to the commission of the crimes, whether materially or by moral encouragement. The evidence we have presented shows that it did. Also, for liability under Article 25(3)(c) and D, it is irrelevant whether Mr. Mokom was part of any grand criminal plan or himself part of a common purpose. Even if this were not the case, it would not undermine his responsibility. He is not charged as a co-perpetrator under 25(3)(a), for example. He therefore does not need to share a common plan, nor have contributed, essentially, or have had control. I'm going to turn now to my second point, Mr. Mokom's mens rea. Contrary to the defense's argument, there is enough reliable evidence for your honors to infer that Mr. Mokom had the requisite mens rea at a minimum for 25(3)(d)(2). And here, let me be clear. The prosecution position is not that he should have known. The position is that he must have known. And I can refer you to our main presentation, where, just as an example, the language is, Mr. Mokom could not have failed to know this. So that's transcript 6, page 87. The defense were selective in focusing on specific evidence while ignoring much of the prosecution's evidence. However, considered in its totality, the evidence is sufficient to infer Mr. Mokom's mens rea. I would like to highlight at this stage another witness's evidence tested in the Yakatomi Ningasona case. It relates to what was known within Mr. Mokom's inner circle in particular. The witness was asked by Judge Schmidt whether he had knowledge of killings of the civilian Muslim population by the anti-Balaka. For the record, the reference of what I'll read out is CAR OTP 50901 at pages 27 to 28. Yes, he says, during the attacks, people necessarily die. Seleka elements are killed. Muslim civilians are killed. And he goes on, so when one came across a Muslim, that was the end of it for the Muslim. This witness was further asked how he knew about what happened on the ground. He responded, well, you know, everyone is aware of what was going on. We had contact with the leaders. And then he continues at line 25. Now we were also able to call people on the ground, elements on the ground, to provide us with more information. In addition to the evidence about what different anti-Balaka insiders knew, Your Honors also have evidence about the additional information Mr. Mokom, in particular, was receiving about anti-Balaka operations because of his extensive contacts with the anti-Balaka leaders and rank and file. And Your Honors also have open source reporting starting from well before the charged attacks. In light of all the available evidence, it's clear that Mr. Mokom must have known. Yeah, I'm moving to my last point, witness credibility. Your Honors, the defense is working hard to discredit P2232. While strictly speaking, this is a matter properly resolved at trial. Let me just point out at this stage that the prosecution's case is not based solely on this witness. He is not the only source for the majority of the prosecution's main propositions. He is corroborated by other evidence, both in relation to Mr. Mokom's role in general and the contributions to the crime. Moreover, while the defense questions P2232's credibility when inconvenient, they rely on him in aspects that are favorable to them. In fact, many of the extracts referred to by the defense in their presentation yesterday demonstrate just how measured this witness is. And I can refer Your Honors here to extracts mentioned, relied upon, where credited, where the witness is credited. Page 35, 41, 43, 51, 55, 57, 64, 87, and 89. Your Honors, to be clear, the prosecution does not purport that any single source is the definitive, authoritative account of the truth of this case. No single witness has a complete vantage point and can tell Your Honors everything you might want to know. In the end, what is important is not any particular source in isolation, but rather the overall picture that emerges from the evidence when considered as a whole. And the overall picture that emerges here, this is my last point, Mr. Mokom was, first, a person of influence within the anti-Balaka from its earliest days, and even more prominently and officially in the February 2014 period onward. Second, a person who made contributions, meaningful contributions, both in terms of material support and moral encouragement to the commission of the anti-Balaka's crimes. And finally, a person who was well-informed and well-connected, both to anti-Balaka leadership and rank and file, and who made his contributions with the requisite mens rea. And with that, I conclude my submissions, Your Honors. Thank you.
Thank you very much. Now, common legal representative of victims, what is your plan there going to be only one of you speaking, or you're going to share the final statements?
Oui, Monsieur le Président, nous comptons présenter nos arguments après la pause. Et je passe 10 minutes, et le prochain sera mon collègue Maître Fall, qui va passer 10 minutes également. Et enfin, Maître Douzima aussi, elle a 10 minutes à présenter ses arguments.
Well then, sir, start your 10 minutes now. We have 10 minutes to 11, so you have the floor for the first part of the
OK.
final statements of the common legal representative of victims.
Monsieur le Président, Madame le juge, Monsieur le juge, bonjour. Et je vous présente ce matin des contre-arguments contre la thèse qui a été développée hier par la défense sur la non-organisation des anti-Balaka, que c'était des gens inorganisés, comme certains théoriciens marxistes méprisaient le peuple en disant c'est une population inorganique. Le mot coordination revêt deux sens. Il y a d'abord un sens tiré du dictionnaire d'agencement logique des parties d'un tout en vue d'obtenir un résultat déterminé. C'est-à-dire là, ce mot est synonyme d'organisation et de coordination. Le deuxième sens du mot organisation ou coordination, ces deux mots semblables dans le dictionnaire, c'est un rassemblement de professionnels momentanés et spontanés dans un but revendicatif, sans mot d'ordre, comme syndical ou parti politique. Monsieur le Président, Madame et
Sir,
Monsieur le juge,
can you pause just one moment? Do we have a problem with transcripts? I see the transcripts are blocked in my...
Merci, Monsieur le Président.
Yeah, now I think resumed. Please continue, sir. Thank you for waiting.
Monsieur le Président, une bonne théorie, c'est déjà une pratique. Lorsque les statuts de Rome ont été préparés par des grands juristes, pendant plusieurs années, ils ont beaucoup réfléchi sur des thèmes principaux, notamment la responsabilité pénale, sur l'instigateur. J'étais moi-même membre de l'Association internationale de droit pénal. On a assisté à Syracuse à une réunion présidée par M. Bassiouni, professeur de droit pénal à Chicago. Nous ne sommes pas très étrangers à ce que le statut de Rome a prévu comme principe du droit, et principes généraux du droit. Alors, la coordination anti-Balaka est bel et bien une organisation, je ne dirais pas terroriste, mais une organisation criminelle. Son but est le retour de l'ancien président Bozizé au pouvoir, et ce, par tout moyen. J'ajouterais même les plus exécrables, comme disait Lénine. Lors de la révolution de 1917, on a connu la suite, les exécutions, etc. Les principaux traits de toute organisation, là je fais appel à des spécialistes de la théorie d'organisation. Et le premier en tête, c'est M. Talcott Parsons, qui dit il existe dans la théorie d'organisation la notion de but pour distinguer l'organisation d'autres formes d'institutions sociale. Et je le cite, en tant qu'élément analytique de référence, l'orientation vers l'atteinte d'un but spécifique est la caractéristique de l'organisation qui la distingue des autres types de systèmes sociaux. Personne ne l'a dit depuis 1960. Dans le même ordre d'idées, mais de façon plus précise, Edgar Schein propose une définition devenue d'usage courant. Il dit « Une organisation est la coordination rationnelle des activités d'un certain nombre de personnes pour l'atteinte d'un but explicite commun via une division du travail et une hiérarchie de l'autorité et des responsabilités. » C'est paru dans son livre qui date de 1970. Cette référence à la notion de but permet de souligner le fait qu'une organisation est un objet artificiel, un objet construit et non un objet naturel. L'organisation est créée en vue de réaliser un projet, d'atteindre un ou un ensemble de buts. Si on lui attribue une finalité pragmatique, on doit expliquer ce qui guide l'action, qui consiste à amener les participants à agir à l'unisson vers l'atteinte des fins ou de buts communs et désirables. Donc, aborder la réalité de la coordination anti-Balaka de la façon inorganique, comme elle a été présentée hier, constitue, à mon avis, une simplification excessive. Rien ne permet d'affirmer, a priori, comme c'est le cas hier dans la tentative de théorisation faite par la défense, qu'une organisation est un lieu de consensus ou qu'elle devrait être présumée comme devant toujours l'être. Non. Alvin Gouldener répond par le contraire. Il observait que dire qu'une organisation est orientée vers l'atteinte de certains buts ne signifie pas d'ordinaire rien d'autre qu'il s'agit de buts de ses principaux dirigeants. Postuler le consensus sans voir qu'il peut ne s'agir que d'un mythe pourrait alors donner à l'éventuelle ambition pragmatique de la théorie des organisations d'un côté partisan. Au moins, faut-il garder en mémoire le fait que le ou les buts qui ont justifié la création de la coordination ou de l'organisation anti-Balaka ne font pas nécessairement et en permanence l'objet de consensus entre participants. Une définition de l'organisation qui attirerait l'attention sur ce point pourrait alors se présenter ainsi. L'organisation, la coordination, est une coalition de groupes d'intérêts différents qui élaborent des buts par négociation. On l'a vu, Monsieur le Président, hier, on l'a écouté de la bouche même du procureur, ici, et de la défense, que le rapprochement entre les anti-Balaka et le gouvernement de transition pour négocier des postes. Vous voyez que la définition cadre bien avec la pratique de cette coordination. Au-delà des débats qui viennent d'être esquissés, l'existence de buts n'est pas le seul trait qui permet de caractériser l'organisation ou la coordination en tant qu'entité. D'autres propriétés, les unes plutôt structurelles, c'est-à-dire ressortissant en quelque sorte à la morphologie de l'organisation. Vous voyez, là, il y a une anthropologie de l'organisation. C'est un problème culturel aussi. Je pense à un des grands philosophes, théoriciens, Antonio Gramsci, qui a développé cette théorie sur la culture, le rôle de la culture et du leadership dans la lutte politique. Ici, la morphologie de l'organisation ou de la coordination apparaît très nettement comme un agrégat de groupes ayant pour trait commun leur ethnie. Je me suis amusé à recenser le nombre de comzones et leur alliance ethnique. C'est 95% de même ethnie que le président Bozizé. Et Monsieur le Président, 3 propriétés d'ordre structurel se retrouvent donc dans la plupart des organisations, sinon toutes. La détention ou la disponibilité des ressources. On vient de nous projeter sur l'écran tout à l'heure un carnet de notes qui liste la plupart des responsables du groupe anti-Balaka. Ils ont également des ressources financières et humaines. Ils ont des ressources matérielles.
Sir, I give you 1 more minute and I have to adjourn for the break. 1 more minute, please.
Merci, monsieur. Il existe des frontières dans l'organisation anti-Balaka. Quelles frontières? La coordination possède une frontière qui permet de distinguer les personnes appartenant à l'organisation avec des badges, des signes distinctifs, la carte d'adhérent, etc. Et ce sont aussi des personnes en tant que telles qui importent, mais leur capacité à assumer les tâches et des rôles qui comptent. Et pour terminer, Monsieur le Président, être à l'heure, la notion de but, lors de la phase de la création de l'organisation, se confond avec les buts des fondateurs. Et donc, les buts peuvent aussi changer et les négociations, à leur propos, déboucher sur des reformulations. On a vu, passage à la lutte, on veut maintenant rentrer dans le gouvernement. Donc, en conclusion, l'organisation ou la coordination anti-Balaka dirigée par M. Mokom apparaît en effet comme un ensemble structuré, sinon figé, contraignant pour les individus qui y participent et en même temps comme une construction collective dynamique qui autorise l'accomplissement des projets communs. Merci, Monsieur le Président. Merci, Madame le juge. Je passe la parole à mon collègue, Maître Yarefal.
Well, thank you very much. Thank you very much, Matt. Now I'm adjourning the hearing for half an hour. We will resume at 11:35. Thank you very much.
All right. We will.